Okay, this is more on the right to fall in love with who you want to, with who you choose, and that is in regard to natural rights. Finally, when I was 9 years old, 1967, the U.S. Supreme Court, a majority of them, decided in Loving versus West Virginia, and I'll tell you how to memorize that case name because you will need to know it. They decided that the right to marry a person of a different race is enshrined in the Constitution, in basically the Liberty Clause of the 14th Amendment. So the way I would remember this huge case is many times these case names have a hint in their very names as to what they're about. And that's coincidental, but you can remember the Loving versus West Virginia case by all time as meaning you get to love who you choose. So the name of the case gives the holding of the case name. And this is 102 years after the North beat the South in the Civil War and ended slavery. Number 5 natural right is the right to be left alone. Now, is that in the Constitution anywhere or in the Bill of Rights? No, but it has been interpreted to be in there by the courts, I think very reasonably so, and it includes the right to personal autonomy over your body, which was key on January 22nd, 1973, when Justice Harry Blackmun, who was from Nashville, Illinois, very well-known lawyer for the Mayo Clinic in Minnesota, was the 5-4 leader and wrote the majority opinion to decide the abortion rights case, Roe versus Wade. Historically, it is also, coincidentally, the same day that LBJ, Lyndon Johnson, who was behind the Vietnam War and not ending it, he died of a heart attack the same day. So where does this right to be left alone come from in terms of the Roe versus Wade case and in terms of the constitutional amendments? Well, the Fourth Amendment says that you have a right to be free from unreasonable search and seizure. That mainly means privacy in your home, and that was used in the Roe versus Wade case to decide the right of privacy in a woman's body. Also, the right of privacy in the Roe case was included in the Due Process Clause of the 14th Amendment, and obviously, even though it may not have been discussed in that decision, women should not be treated differently than men in regard to reproductive rights. So this right to privacy was first articulated by law professors in Harvard Law Review, one or two of which ended up on the Supreme Court. I believe one of those writers of that opinion of the right to be left alone, or the right to privacy, as the name of the article is, was Justice Brandeis, who I think was a professor there. Number 6 natural right. The right not to be discriminated against over your immutable characteristics. Things that you cannot control, whether you're black or white, whether you've grown up in the Muslim religion or the Christian religion. Things that you have no control over necessarily, like skin color, whether you're thin, whether you're short, whether you're tall. So if you look in terms of race at little kids playing in a little playground in the mall indoors, like I have recently, and let's say they're 1.5 to 3 years old, and how they interact with one another. Kids who look differently from them. Kids do not care. They're just interested in playing, and they're making judgments instantly, like we all do about people, good or bad, based on what they see and how people behave. The number 7 natural right is the right, and this has to do with the right to be left alone, the right to non-aggression, the right to not be aggressed upon physically, emotionally, the right not to be harassed by other people. But mainly we're talking about the non-aggression principle in libertarian theory about the right to do physical harm on one another. So we believe that no one should aggress against you except in true self-defense. That would apply on national security. That these wars of killing brown people ever since 9/11/01 have not helped us. They've maybe made more terrorists in the world, and we don't believe that any of those wars were justified, and we believe that all those wars ongoing now should end immediately. So this is what upsets us so much when we see the George Floyd video, this Calvin guy or whatever his name is, with his knee on the man's neck for 8 minutes and 49 seconds, almost 9 minutes. And we see a murder happening before our eyes because this is an unarmed man This Derek character, that's his first name, I think, of this police officer, had 3 other officers there to help him, and I question whether or not Mr. Floyd should have ever been taken into custody, even if the police had probable cause to believe he tried to pass a $20 counterfeit bill. In my mind, in Illinois law, that would be a ticket, misdemeanor ticket, for attempted theft under $300. So why do fair people have a naturally visceral reaction of disgust and loathing at that behavior of that officer? And to see Eric Gardner on video, very famous tape in Staten Island, killed by police, chokehold, when he's telling them, I can't breathe. Now, they can obviously see that Mr. Gardner was an older man, overweight, likely had pre-existing conditions. And they did this because they wanted to take him into custody over him not paying cigarette taxes on loose cigarettes. Let me repeat this. Mr. Gardner was killed over an unknown amount of taxes. I don't know how they even make that case. That he was selling apparently $1 loose cigarettes. And the state of New York wanted their taxes. And this shows you what eventually will happen to you if you don't pay your federal taxes. They will come at your house with a warrant, and they will come with guns. And they will seek to take you into custody until you're convicted, and then you go to prison. So in that case, let's say that they had the ability to prove, which I sincerely doubt, that Eric Gardner did owe $10,000 in state cigarette taxes. Well, innocent taxpayers, as a result of this outrageous behavior of these officers, had to pay his family, and I just looked it up, $5.9 million in compensation for the wrongful death of their loved one. That was in a civil case. You do have a right in federal court under the 7th Amendment, by the way, to a jury trial in a civil case, and that was federal because Eric's federal civil rights were violated. So think about this. They wanted to make $10,000 off the man, and they end up paying almost $6 million. And I would submit to you, ask yourself, is that what we want our police officers doing as a matter of policy? And that policy is set mainly by politicians, some of whom are thoroughly corrupt. So does that conduct make any sense, to have to pay out $6 million to try to make $10,000? Put aside the immorality of killing him and executing him on the streets without trial. Number 8, federal or a natural right is, and this is a right that you and that cops have, and that is the natural right to defend your life. It is the natural right recognized by the Supreme Court in the Heller versus Washington, D.C. case about, I think that was in 2008, decided by Justice Scalia 5-4. He decided that the Second Amendment language, which is contradictory about whether or not it's an individual right to keep and bear arms or whether or not it's a right if you're part of a militia, he decided that very narrow case that in Washington, D.C., which is federal law, the federal law that banned any handgun ownership by an individual violates the Second Amendment, and he does mention the natural right to defend one's life. And of course, the natural right to self-defense must be reasonably exercised. But cops in the case law, starting with Tennessee versus Gardner about 1985, seem to get special rights in regard to self-defense. And you see a lot of law, and we will go into this extensively in these discussions, about, an officer in that officer's exact position, or given what they think is true, where they're mistaking. There was the Diablo case in the late 90s, early 2000s that arose in New York City. And these police officers, and a lot of them, they were looking for a guy, and they thought it was Mr. Diablo. Turns out there was not a warrant out for him. Let's say there was. And Mr. Diablo is in a vestibule of an apartment that is lit up, and these officers outside can see that he's messing with something brown. Well, they shoot him 42 times, they kill him, and in fact they find out right away that he was messing with his wallet to produce his ID. Now, to the credit of some of these officers involved in this, to show their humanity, they were on the steps of this building once they found out the truth, weeping, and they took seriously what they did. I do not believe that any police officer was prosecuted over that case. There was very likely a civil settlement. But when you do a term paper for me, you can do a term paper, 8 to 10 pages, about the Diablo case in New York City in, I think, the last decade. Number 9 natural right, this is in the First Amendment, is the right to freely express yourself through cave drawings thousands of years ago, through painting now, through classic art type of expression, through free speech. And I would note that political speech is given the highest level of constitutional protection in the United States. The right to write what you want to do. The right to not have your book burned. I've been seeing book burnings in some of these cities in the western U.S., in Seattle, in Portland, and it's frankly disgusting because that is what Nazis did from 1933 to 1945 in Nazi Germany. Free expression includes, of course, movies and TVs, but it does not control what the Supreme Court has said is federal communications operated and regulated radio. In other words, you do not have the right to go on radio and say the 7 dirty words you can't say on television by George Carlin. And that case went all the way to the Supreme Court. It's called FCC versus Pacifica. That was decided in the, I think, early 70s, where they decided that a radio station could be fined for playing that 20-minute bit, which is a classic bit by George, at night. Even nude dancing has been held by the courts to have First Amendment value. So in general, the government has no legal right to suppress and advance any kind of speech in the United States. Now, unfortunately, there are many exceptions to that will be discussed in this course later. Number 10, natural right. If the leader of the tribe of hunter-gatherers, let's say they have a chief, had to mediate or decide a dispute among two people in the tribe or among one group of the tribe versus the other, let's call them litigants. They're early litigants. I would submit to you that those litigants would expect, in the natural world, the right to have a fair process, to not have the leader of the tribe have his thumb on the scale of justice and favor someone he was closer to over someone else. Now, that is recognized in the Fifth Amendment due process clause that affects the feds, the 14th Amendment that affects all other forms of government, and that is a right to a fair process. And as you know, I believe a fair process yields a fair result. The number 11 natural right I believe we have is the right, even in that theoretical or historical tribe, to compensation if one is wronged. That is definitely in the First Amendment, free speech, the right to petition the government for redress of grievances, and 3, the right to peaceably assemble. It's also recognized the right to compensation if civilly wronged, which means mostly for money, to get money. That's recognized in the 7th Amendment to the Constitution, that people in federal civil cases have a right to a federal jury trial. Now, number 12, natural right. If the tribe does punish someone, let's say the leader of the tribe has the authority to do that, it was natural for those people to expect that punishment would not be excessive. That is in the Constitution too. The 8th Amendment says that cruel and unusual punishment shall not be inflicted, and that, of course, was decided by the Supreme Court to also apply to the states through the 14th Amendment due process clause, because originally the first 10 amendments were only directed toward the federal government. And finally, 2 more natural rights. Isn't it natural to expect when you work to be paid for your labor? I mean, 620,000 American lives were lost in 1861 through 65, deciding this question for all time. It was not just the right of Southern secession, it was the reason for why the South wanted to secede from the Union, and that was to still allow slavery in their territory. So, is that in the Constitution? You bet. 2 of the Civil War, post-Civil War amendments. 13th Amendment bans involuntary servitude. That means everybody has to be paid for their labor in the United States. And of course, the 14th Amendment due process clause gives black people and minorities the right to equal protection of the laws. And the final natural right is that the right to non-discrimination on account of your gender. That would be unnatural to expect now in our modern sensibilities, women to be treated any differently in the tribe than they probably were men, because they were bigger and stronger, probably had the upper hand. But in the United States, in two amendments, the 14th Amendment, due process equal protection clauses, gives gender rights, non-discrimination rights, and the 19th Amendment that was decided in the last 100 years and passed by Congress in the states prohibits the right to vote being denied on account of sex. So half the species of Homo sapiens now in theory have equal rights in the United States. Okay, this is the end of this segment, and I have a little introductory part to the Civil War video you're going to see tonight that's a little bit more than an hour and a half long, so thank you.